So what do we mean by debt capital? Debt capital refers to borrowed money. We talked about share capital. When you want to be a member of a company and you buy shares, you pay up the prescribed amount, you provide money for the company to continue with its operations. You are a shareholder. But more often than not, this money is not enough. So the company will resort to borrowing additional funds. And most are long-term bonds. The shares represent ownership, and they have a say in how the company is run. Remember, that is one of the disadvantages of the IPO and subsequent offering of shares. So the company, in a bid to balance how they run their affairs, will result to debt. And it's an investor agreeing to loan the business. Once the investor agrees to loan the business receives this debt capital and agrees to pay back with additional interest payments that are compounded as long as the loan is active. So the safest type is a long-term bond, because the assumption is the company has years to work. It has years to repay. And we talk about a debenture. A debenture is a document. It either creates a debt or acknowledges it, and it is a debt without collateral. What does this mean? There's no asset attached to it. They have given the company money, but this agreement is not based on, let's say, that piece of land which the company owns or the cars that the company owns. And it is used for a medium to long-term debt instrument. So in some countries, it's used interchangeably with the term bond or a loan stock or a note. Therefore, it's like a certificate of loan evidencing the fact that the company is liable to pay a specified amount with interest. And while this money becomes part of the capital structure, it does not become share capital. So these debentures are normally freely transferable. And you remember, we have distinguished between that share capital. Those that contribute to the share capital have voting rights, which is why they are called upon to pass resolutions, to pay off dividends and such. What debenture holders have is they earn an interest. And this interest, it's against profit. In that sense, their interest will be paid first before the dividends are declared. So how does a company get capital to finance its operation? We have talked about the issue of shares, and now it comes to borrowing. So unless the memorandum prohibits the company to borrow money, there is that implied, the memorandum and articles have given the directors implied powers. So unless they specifically prohibit, then the directors can go ahead and borrow to be able to finance their operations. Again, we talk of directors exercising these borrowing powers, and they must act for the good of the company. They must act subject to what is provided for in the memorandum and articles of association. Anything that is not within those powers, again, is ultra vires. So while they have the discretion on how to borrow, who to borrow and when to borrow, they don't do it without limit, which is why we talk of ultra-vires borrowing. And this is where, if the directors go in excess of limits placed by the memorandum and articles, beyond the powers of the company, any such borrowing is null and void. And the lender has no legal or equitable right against the company. Why do we say the lender has no legal or equitable right? Because the memorandum again and articles are public documents. Before you engage with a company, you are supposed to read to what extent can you fund them as provided for in the memorandum and articles. But there are equitable remedies. And one is the proceedings for injunction. These will only work if the company has not spent the money the financier gave them. So you obtain a letter preventing the directors from and the company from spending that money. And you're able to recover the money if the money is existing. So for this injunction, you first need to identify that if, for example, a financier gave company B money to buy a new tractor, probably it operates in the agricultural sector. If you are sure that the money has not been spent, you go to court, ensure that you get an injunction, and you're able to recover the money as is. We also talk about an order of subrogation. And what is subrogation? You remember, we have talked about this borrowing, the lender having no legal or equitable right about that. But when you claim to an order of subrogation is you go into the shoes of a creditor, where if the money is applied in paying off the lawful debts of the company, you as the lender, you're entitled to step into the shoes of a creditor who has been paid off and be subrogated to their rights. You rank as a creditor who the company legally owes money to. So that order of subrogation is you're placed in the shoes, so to speak, of a creditor whose debts have been paid off. And in this aspect, where the money has been paid off to deal to finance the company, you are given those rights of that of any other creditor. We talk about identification and tracing. In our previous example, we talked about a tractor. If the money has been used to pay for that tractor, you as the creditor, you can identify and trace and recover. You identify that you gave the company 20 million. This 20 million was used to pay for that new tractor or 10 new tractors. The court allows you to go and identify and recover that asset to be able to recover your money. We also have the recovery of damages. The act itself was ultra-vires. The directors went beyond the powers given to them by the memorandum and articles. So what do? You go to the directors individually, personally, and recover from them for a breach of implied warranty of authority because you assume they were working for the good of the company. Again, we say, if that acting ultra-vires could have been discovered in the memorandum, you cannot go for a recovery of damages because you knew and went ahead to transact with people who had no capacity to transact with you. They had no powers to bind their company from entering into a contract with you we talk about again that tractor. The company had no powers. The directors had no powers to buy these tractors. The memorandum clearly states that they lease. So when you as the creditor provide money for the buying of that tractor and you have realized you cannot go for the directors themselves because you entered into that agreement knowingly and you proceeded to go ahead and finish up that. So for the borrowing ultra vires, we have this indoor management rule. And the ruling in the Royal British versus Tarquin is what guides us. There are various rules. Ultra-vires borrowing in excess of the powers, but not of the company. You see, there are two different things. Where the directors have been told you can only borrow to one billion, but the company has provisions for more than that 1 million. So there are two different things. The director has acted ultra-vires to his powers, but the company has powers to go way and over and above that. And what happens is that this borrowing can be ratified and validated by the company. And if the company ratifies and validates it, both the lender and the company enter into a contract as if it was valid from the start. But if the company refuses to ratify, the normal principles of agency and the rule of indoor management will apply as long as the lender provides that he lent the money in good faith and without notice. So two things must be done where the company refuses to ratify. You see, when the company ratifies, there are no issues. The contract proceeds as was expected and life continues. Where the company fails to ratify the rules of agency, the director is deemed to be an agent of the company. And this is what we are talking about, the indoor management rule. So in this case of Royal British versus Tarquin was sued as the official manager of a coal mining and railway company on a bond for $2,000, which had been given by the company to the plaintiff bank to ensure its drawings on a current account. The bond was given under the seal of the company and signed by two directors and the secretary, but the company alleged that under the terms of its registered deed of settlement, the directors had powers to borrow only such sums as had been authorized by a general resolution of the company, and in this case, no sufficiently specific resolutions had been passed. The court held that the company was bound by the bond. So, the principal is liable if the agent does what is actually authorized to do, what an agent of that type would normally have authority to do, or what he has been held out by the principal as having authority to do. So the issue is that the other party must not have known that the agent was exceeding his actual authority. We talked about the memorandum and articles being public documents. So you as a third party dealing with the company, you are not bound to ensure that internal regulations have been complied with. You see, these are internal dealings. The external, you may be bound, but internal dealings of how that company is run is not up to you. And this rule is based on the convenience of business transactions because business cannot be carried out effectively if everyone who has dealings with the company goes ahead to meticulously examine its internal machinery. That is, take for instance, when you go to a bank and you're served by a teller. It's not your business to know if this teller has been with the company for how long, the amount of money they're allowed to transact. If that was the case, then no business would commence. You would first start with following the rigorous chain of command so that you're able to determine who are you going to deal with and for how long. So the indoor management rule is that you need not follow the internal affairs of a company in order to deal with them. So these are the rules set out. And rule 1 is that anyone dealing with the company is deemed to have notice of its public documents. So whatever is contrary to that file with the Register of Companies, whatever is contrary to the memorandum and articles of association, it will not bind the company unless, as we have said, the company ratifies it. Rule number 2 is that provided everything appears to be regular, in as far as you can confirm, an outsider is entitled to assume that all internal regulations of the company have been complied with. So when you get a contract from a company and on the face of it, a director has signed, on the face of it, the company secretary has appended their signature, then you as the third party, you need not go further and identify how did you people come up with this individual as the company secretary. So rule number 3, an outsider dealing with the company through an officer who is or held by the company as a particular, for example, a managing director, or who purports to act as such and is acting within the powers that normally that managing director would act. You're entitled to believe or assume that these acts are directly from the company, even if the officer has not been appointed and has exceeded his actual authority. So when you, for instance, as a creditor, you go have a meeting with the company officials, an individual represents himself as the managing director and goes ahead and signs and stamps as the managing director. And these are normally the transactions that he does. Authorized transactions over 2 million, for example. It's not your business to understand how this person got there and if he's acting, how that person is acting. You can't know whether this is a fraudster. You have found the person in the company. They have appended the seal. They have given you directions on how to transact. So you assume that the person has all the powers vested into them. So in this one, we rely on the case of Freeman and Lawyer versus Backhurst Part Properties, where the defendant company was formed to buy and resell a large estate by Kapoor, a property developer, and Hoon, who contributed half of the capital but played no active role in the company's business. So Kapoor, Hoon, and a nominee of each were appointed 4 directors, and under the articles, all 4 are needed to constitute a quorum. Hoon spent much time abroad, leaving all the day-to-day to Kapoor. After the initial land to resell the land failed, Kapoor decided to develop the estate and engage the plaintiff, a firm of architects and surveyors, to apply for planning permission. The company later refused to pay on the ground that Kapoor had no authority to engage them. The court held that the company was liable by its own acquiescence. It had represented that the director was a managing director and has been acting as such to the knowledge of the board. But this can't work if an outsider knows that the officer has not been appointed, and again, the public document makes it clear. So for this case, this silent partner kept quiet. Therefore, the court could not protect the company or exceed or excuse its liability when the one person who was seen to be running the company actually ran the business of the company. So rule number 4 is that if the officer is purporting to exercise an authority which that sort of officer would not usually have, the outsider will not be protected if the officer exceeds his actual authority, unless the company has held him out as having authority to act in the manner and this outsider relied thereon. When we talked about the managing director, the reason why the law will side with you is that you found him in that capacity. He signed documents in that capacity. But when you go into that company, you identify an individual who, let's say, you find a clerk or a junior employee, and you decide to engage with this person, yet no one has given you that, no one has told you you can relate with this one because this is the managing director. It's where you find someone and assume they have powers. Yet the company had not at any given time sent out this person to act. So probably the employee was very excited about handling a huge contract, handling huge sums of money, and you are brought on board. But this employee had no capacity. And the company never told you, when you come and go to 16th floor, deal with A, B, C, and D. Then there you cannot purport to recover any damages. So rule number 5, which will be our last rule for today. No, we will finish the rules so that we can start on debentures in our next class. Rule number 5 is an outsider who can bring himself within the protection of rule number 3 and 4 would not necessarily lose his protection because the officer had never been validly appointed. Again, we say these rules, they are not set on stone. So if you can be able to fit in any, it would work. And that is what rule number 5 says. See, rule number 3 is that of the managing director. Rule number 4, where there is no express intention to act in that authority, that doesn't mean necessarily that you won't be protected. So rule number 6 is where we say, if a document purporting to be sealed or signed on behalf of the company is proved to a forgery, it does not bind the company. In Ruben versus Great Fingal, the plaintiffs who are stockbrokers had procured a loan for one, a secretary of the defendant company on the security of a share certificate for 5,000 shares held in the defendant company, to which Rowe had affixed his own signature and the company's seal and had forged signatures of 2 directors. The plaintiffs, having reimbursed the mortgage, claimed damages from the company for failure to register them as owners. So, the court held that the company was not stopped by the certificate. The forged certificate is a complete nullity, and the doctrine of indoor management cannot apply to it. This means a forged certificate is beyond, you can't claim that these are the dealings of the company in issuing, because they do not forge certificate and issue to people. However, the company may be stopped from disclaiming the document as a forgery if it had been put forward as genuine by an officer acting within his usual or apparent authority, and a transaction is binding if, under the foregoing rules, a company will be liable, notwithstanding the officer had acted fraudulently or committed a forgery. So where it's put forward, this share certificate, there's no element of the company has not denied it. The company has not issued a warning. This company cannot be stopped from being liable to that. So we finish, what are the limits of the indoor management rules? One, we have void act, where the act is void ab initio from the beginning. It cannot be, the company cannot be bound. So we said the acts that the memorandum of articles are not provided for in the company, and such acts from the onset, they were never supposed to happen. So they cannot, the indoor management rule cannot apply. If a company is selling land and you enter into an agreement for the purchase of motor vehicles, the articles never provided for such. The memorandum never provided for such. So it doesn't apply. So where also there's the knowledge of irregularity. When you are dealing with the company and you are well aware that the prescribed procedure has not been followed, you're dealing with the company, you know that the company must have a special resolution, and you go ahead and act without that special resolution. An irregularity has happened of which you are aware of from the onset, then you can't say these are the insider dealings of the company, so I need not know about them. No, that indoor management rule will not apply. So when there's lack of authority, that is when an agent makes contract with a third party and that agent falls outside the ordinary authority, the company is not bound. Where someone has no authority to transact with you, they have acted way above what they were supposed to do, then that company cannot again proceed to, those limits will not apply.